Hello and welcome to Let's Be Honest. I'm your host, Just Johnda, and tonight we are jumping right back into our blurred lines, sex crimes, and true alibis series. And as you know, if you've been following us, this is the series that we're doing based on several people, one being the Reverend Donnie McClurkin, Timothy Busfield, who I thought we were going to get to in part two, but Donnie McClurkin popped in there in the middle. And so we'll get to him in part three. And of course, rounding out part four with Tyler Perry and the latest. This has been a few weeks, but we're still going to talk about it. We had several requests about the Tyler Perry cases. So we're going to cover them both because one was filed in June and the other was filed at the end, right around the new year. So we're going to jump right in because tonight we're going to have a good time, but we're also going to learn a lot. Because let's face it, we pride ourselves over here as being the smartest people on YouTube and, of course, in the podcast space as well. So for those who are joining me on the podcast, welcome, welcome. And for those who are joining me on YouTube, especially those watching live, hello. Do not hesitate to put things in the comments. I am watching for your comments, and I will also pop them up on screen and answer your questions as we go along as well. So for those who are watching on YouTube, this is absolutely interactive. And for those who are listening on the podcast, I will definitely read the question so you know what I'm answering. So again, we are going to jump right in because there is a lot. So unless you didn't read the first one or you don't follow the pretty janky church gossip, then you may not know, but I'm going to tell you that Mr. We fall down, but we get up. Donnie McClurkin, Reverend Donnie McClurkin Jr., is being sued by a man named Giuseppe Corletto in the Supreme Court of New York. Now, just briefly on the allegations, because you can go back and read and listen to all the gory details in our first episode about this, which I will link in the comments because it's a good episode. And boy, are the details juicy. So just to sum it up, Mr. Corletto alleges that when he was in his early 20s, that he was going through a crisis about his sexual identity. I believe he was around 23. I'm going to pull it just to get some of the ages and some of those things right, because they do factor in just a little bit with these defenses because of the time frame that some of these things occurred. So anywho, I've got three screens going here, by the way, guys. So at any rate, so I'm going to go back to the facts. So this all allegedly began, I did have the 3 right. I was thinking 23. This all began allegedly around August of 2003 when Mr. Corletto was 21. So that's why I said I had 3 right. And he claims that he first met Donnie McClurkin in his church in Long Island. Now, again, he says that his going to Donnie McClurkin's church was based on him having a crisis of faith, and especially as it relates to his sexuality, and that he had read Donnie McClurkin's book where he essentially said he prayed the gay away. Donnie McClurkin has infamously talked about how he used to be gay and now he is not, and moved on to have a life with women and all the things. Well, Mr. Corletto alleges that he went to avail himself of that, in particular because McClurkin was doing ministry without walls, or ministry beyond the walls. And once he went to him, not only was he hit on someone else who McClurkin allegedly came to the rescue from. It was a whole little weird, convoluted way that he ended up in the inner circle. But in short order, he ends up working for McClurkin, traveling with him. And all of this is alleged, of course. This is in the original complaint filed by Corletto, that he ended up working for him, traveling with him, had various experiences, intimate experiences with him. I'm trying to monitor what I say, especially in the YouTube space, because we're still within the first 15, 20 minutes. But, and that those experiences were either coerced or forced upon him by McClurkin. And he alleges that this situation went on for many years. He would leave. He even began working someplace else. But that this went on for some time. He alleges that these unwanted intimate acts, where McClurkin would perform acts on him and or force him to watch him do things to himself, that they would go on at the church. They would go on before services. He would be sitting crying during services, watching him preach, knowing what had just been done to him. And as I said, would even travel with him. He talks about occasions. We're going into 2003, 2004, 2005, 2006, 2007. So about 6 years straight that he alleges that these things went on. And then at one point, now we're all the way up to 2008, where he allegedly left and secured employment elsewhere. And he would encounter him still occasionally, because where he secured employment was with a Christian broadcasting network, still in New York. And of course, McClurkin, being a gospel artist, would pop through occasionally. So he would encounter him there. He says later on, now we're talking almost 10 years later, 2012, he was allegedly working for an airline, and McClurkin essentially tracked him down. He allegedly discovered where he was, and the next thing you know, he's there. For want of a better way of putting it, McClurkin's there. He's in the space. He's in the place. And then he's in his place, if you know what I mean. And so he said that this continued to go on during that time. He allowed him to stay in his room. That part was a little weird, and that acts took place there. He claimed that in 2013, McClurkin showed up at his home in Boston. He then claimed that McClurkin later asked him to not move in with him, come back to the church. Again, this is 2013. I'm sorry if you hear yipping little puppies in the background. I always say the people in my house have dogs. I don't. So, and those little ones are very annoying when anybody's near the house, driving down the street, in the driveway, not in the driveway. I swear, they go nuts if someone flies over the house. In 2013 is also when he claims that McClurkin issued the infamous apology that has been posted umpteen times and read all over, where McClurkin allegedly says, in part, I am the actual epitome of a desperate, dirty old man pawning and groping a young man who is just looking for a friendship and close platonic relationship with someone he wants. Well, the grammar isn't great. He wants to look to for help, guidance, and spirituality. I was trying to go to a realm of sexuality that wasn't right, and wasn't right for you, or me for that matter. I feel so foul, so stupid. I'm old enough to be your father and want to be something else to you. You don't have that desire for me, and I shouldn't have it for you. I force myself on you, groping on you, and when I think about it, You never really touch me like that at all. Just wanted to sleep together and hug occasionally. I am really embarrassed at how I am and how I acted. Now, that's just in part of, again, the apology that was posted in the complaint, but of course, talked about wherever. So that is the big picture. It is allegedly this saga that went on for the better part of 10 years when this gentleman who brought the complaint was between the ages of 21 and, well, I guess 31. So needless to say, in his answer, Mr. McClurkin, via his counsel, did what we expected he would do, which is deny everything. And quite frankly, if you haven't decided what you're going to do with this case, if you're going to try to settle it, fight it, whatever it is you're going to do, fighting it is probably what he's going to do. I mean, his entire reputation rests on this. So that he just denied everything. I mean, it is page after page after page after page of denials. Some of the denials have explanations as it relates to time and place. So we're going to get into that, because not only did he deny everything, but he actually did a series of affirmative defenses. And so we're going to talk about that, what that means, why you do that. And I'm going to go through the affirmative defenses one at a time. Some of them are fairly self-explanatory, but some of them get deeper into the actual laws that these claims are based on, especially the Victims of Gender Motivated Violence Act in New York and the extension whereof. So we're definitely going to get deeper into that. So let's jump right in with me reminding you of the causes of action. So there are three that Giuseppe Corralato, and I apologize if I'm saying his name wrong, because now I've shifted to screen 3 with, I've got my laptop going, desktop, the whole thing. I've shifted to my other screen, which is where I have my notes about the actual denials. So the first cause of action is violation of the Victims of Gender Motivated Violence Act. Now, the Victim of Gender Motivated Violence Act, as we have talked about quite a bit, especially as it relates to the Cassie case, and which of course started the house of cards falling in the Diddy situation. That is the law in New York that, of course, makes it illegal for someone to commit certain classes of acts against individuals as a result of their gender or gender identity. And so in this case, the allegation is certainly because of his gender identity, in this case, being homosexual, bisexual, whatever the case may be, that these acts were committed against him. But in order for even the civil case, in this realm, it needs to be proven, or at least alleged, that the acts, and there are certain enumerated acts, that the acts that were committed were acts that would normally be this that would carry jail time, and certainly they would fall sexual assault, sexual battery. Those are serious acts that fall under this law. But most importantly, they are acts or crimes, because I'm tired of using the word act because it's the Victims of Gender Motivated Violence Act. They are crimes that the statute of limitations has already run. And because the statute of limitations has run, there's nothing that the police can do for you. So your only alternative would be to sue them civilly. Well, there was a 5-year statute of limitations on that. Even if it was a situation where the person was a minor, then they turned 18, and then you have X number of years from the time you turn 18. And every state has a different number of years that qualifies with that. So because of that, there was the gender motivated violence. There was an extension, rather, of the Gender Motivated Violence Act. The first time this time extension happened was when the law was initially put in place, which was in 2019, and then it was further extended in 2022. So that's why you hear that whole deadline thing about how Cassie's case was filed in the 11th hour, right before the act ran, because even with the extension, there was a statute of limitations on that extension as well, which has subsequently been extended multiple times, including in January 2026, where it was reinstated by the current mayor of New York, because the previous mayor, Adams, which we have an episode about that dude, the previous mayor had repealed the law. So, and that's actually going to come up in these affirmative defenses as well, because in quite the convoluted fashion, his attorney tries to claim, well, let's jump right into it and I'll explain it. Okay, so affirmative defense number 1. The complaint fails to state a claim upon which relief can be granted. Now, or may be granted. Now, that is a catch-all for a lot of cases, and it's always number 1 when you're filing a motion for summary judgment, which is a motion that we file to get the court to look at the case as it stands right there and say, there's not enough here for me to move forward. And this is not like a criminal case where everything is in a light most favorable to one side or the other. So that is the first thing. So essentially, you're just saying, there's nothing here, sir. There's nothing here. You're making claims, but there's nothing here. You're saying that I may have done something to you in after you were 21 years old. What did I do to you? Well, that's what we're going to get into. So essentially, you're saying what the defendant is saying is, plaintiff is full of sugar honey iced tea. Let me see, where am I? I could say it. Plaintiff is full of shit. None of this happened. None of it even sounds plausible that I took this 21-year-old man and forced him to do this, that, and the third, and that he kept coming back to me. He worked for me at my church. I continued to do things to him over a period of time spanning 10 years. He worked at an airline. I tracked him down in Florida. I tracked him down in Boston. None of this makes any sense. The claims are all fantastical and goofy. So there's nothing here to grant relief because there's no real claim here, sir. None. There's no sexual assault. There's no sexual battery. This doesn't even fall under the Gender Motivated Violence Act because of the 5011 affirmative defenses that I'm going to get into. So right out the gate, no claim. So that's the first one. The second one, the plaintiff's claims are barred in whole or in part by the applicable statute of limitations. That is another one where the affirmative defense, in my opinion, doesn't stand on its own because of the claim that he is making, because he's making the claim under the Victims of Gender Motivated Violence Act. And of course, we know that the statute of limitations was extended based on that. That's fine, because just in case the judge sees it that I do and go, that one's not really here or there, we've got affirmative defense number 3. because he's got a little something for everybody. So, affirmative defense number 3, this court is not the proper venue because none of the allegations raised occurred in New York County, and New York County has no relation to the incidents raised in the complaint. So this one essentially says that whether the court or trier of fact, if it's a jury, believes any of the crap this dude says or not, and I'm saying that's I'm not saying it's crap. I'm speaking as if I were the defendant. Whether the court believes anything this dude has to say or not, it doesn't matter. We don't even get there because all of the things that he is complaining of, allegation after allegation, either happened at some hotel we supposedly traveled to. It happened at my church, which is in Long Island. It happened in Florida when I allegedly tracked him down working at the airport, or Boston when I found him there and begged him to come back to my church. So even if anybody were to give 1 ounce of credence to what this guy is saying, by his own allegations, none of it happened in New York County because my church is in Long Island, and all the other places that he said this stuff happened were all over the country. So the incidents raised in the complaint, believe them, not believe them, whatever, not the proper venue. And of course, venue is important. And venue is important for it on both sides. Venue is important in terms of McClurkin raising this defense, and venue is important in terms of the plaintiff because New York County, or even the city, whatever, wherever you claim it happened, Manhattan, whatever, that is where the statute of limitations is extended. So that's very important there. And back to the fourth affirmative defense piles on with the third one, which is no nexus to New York, so it doesn't fit within the extended statute of limitations of the Gender Motivated Violence Act. So now we're going to dig a little deeper on that. So this law, which provides an 18-month window for victims of crimes motivated by gender occurring prior to January 9, 2022, and of course, that has been extended again, but I'm taking us back through the history of it. It provides them with the right to pursue an action against any party who commits, directs, enables, participates in, or conspires in the commission of a crime. So this is the Diddy stuff. This is also some of the R. Kelly situations as well. Although in the R. Kelly instance, you had the fact that he was charged criminally. But with civil suits, which have been filed, the stuff that happened in New York and a couple of other places who has done the same thing New York has done, that's where they're able to get in civilly, because as we know, some of the crimes alleged against R. Kelly had happened years before as well. But he still had a bit of a window there, or his victims still had a bit of a window in terms of the statute of limitations, especially since some of the allegations against him had allegedly occurred. I mean, some, obviously the Aaliyah stuff many years ago, but then there was the allegation of the ongoing issues, even almost to present day, a la the RICO piece. But back to the crimes of violence motivated by gender. So they, of course, have a list of enumerated crimes, which, sexual assault, sexual battery, that all falls underneath. That window was extended, that 18 months, that was extended several times. And so now, as of January 29th, 2026, it has been extended another 18 months. So now it's going through July 29th of 2027. And again, this is provided the abuse occurred prior to January 9th, 2022. Why is that relevant? Because stuff that occurred after that, especially if you're suing right now, you're still within the normal statute of limitations. So it sort of shifts a little bit because based on when you bring it in relation to the statute of limitations, it may or may not fall out of that, but you're still good if you're bringing it now. I hope that makes sense. Because it's still open. So like if something were to have happened to you in say 2023 or 2024 and you brought it now, you're still good because that statute of limitations is still open anyway. And there has also been in many states some adjustments to the statute of limitations on the underlying offenses from the criminal side as well. So and as is here, abuse occurring on or after January 9, 2022 is governed by New York City Administrative Code section 1105, which requires that an action be commenced within 7 years of the crime or 9 years from the cessation of the disability. And the disability for many is, a disability could be a normal disability. There is a reason why the person wasn't able to bring it. It could have even been related to the crime. But it's also if the person is under the age of 18, because if you're under the age of 18 and nobody around you were to press charges or file a lawsuit, you're a kid, what are you supposed to do? So of course, once you turn 18, then the time clock starts to tick on that for you. Okay. So there is also, because of the former mayor, because of him putting a stop to this, the statute also permits individuals to amend and refile dismissed lawsuits that were brought between March of 2023 and March of 2025, because those lawsuits didn't permit that whole predating of 2022 because of what Adams did. So the bottom line is, it's basically a free-for-all until 2027 on the pre-2022 people, and anybody after that, you have your normal statute of limitations. If you have questions, well, that's what the comments are for if you are listening to this live. If not, I hope that you are watching later for my replay gang. Like, comment, subscribe. And in the comments, if you have questions about it, I'd be happy to even do a follow-up episode, or we can talk about it in the comments. You know what? I forgot to put one of my banners on here. I'm going to do it right now. There we go. Reminding you to like, comment, and subscribe. And if you are listening via podcast, make sure that you are liking it, commenting, giving it whatever number of the highest stars you can give it on iTunes and all the things. Okay, so next we are going to go into affirmative defense number 5. So as long as you know, 3 and 4 go hand in hand. 4 kind of shores up the point they were trying to make in 3. So affirmative defense number 5, the doctrine of impossibility. Now, typically you find this one under contract law, but his lawyer said, we're tossing in everything but the kitchen sink. So that means if we got to find contract law things to toss in, if we can use it to try to defend against this, we're doing it. So hell, why not? Doctrine of impossibility. Here we go. So it generally applies where performance is impossible, okay, due to changes in the law, the death of or illness of an individual, the destruction or change in character of the contract. So that's why it's really weird that they kind of threw it in here. Essentially, the event that creates the impossibility. So that's the other thing. The event that creates the possibility has to be something fortuitous. It has to be something that the parties couldn't control. It can't be something that someone did to excuse performance. So I gave a lot of thought to this about how they would argue this in summary judgment. I'm still, and I can come up with pretty much any damn thing. Other than stating the obvious that it just simply couldn't happen because of time or place, I'm assuming that there may be an argument that it simply couldn't happen because if I'm trying to get into the mind of the defendant and what a lawyer would argue, just throwing it all in and seeing what sticks, even if it's a little icky. Maybe they're going to argue that he couldn't have possibly done these things because he was cured from being gay before he even met this guy. So he couldn't possibly want him. He wouldn't have possibly been able to perform. It's not typically used in these circumstances. That's why it works so well in contract law, because in contract law, if you have somebody who you contracted with to especially if it's something that is specific to that person, like you contracted with a midwife and you didn't contract with a whole midwife service, you contracted with a specific midwife because you chose her to deliver your baby. You had reasons why you wanted her. You wanted Erykah Badu and nobody else. And she dies or gets debilitatingly ill, then obviously there would be an argument there from, let's say if she dies, the estate, who, you might sue and say, well, she didn't show up, she didn't deliver my baby. Then you bring in the doctrine of impossibility there because you didn't hire service where somebody else could come in and take her place. You wanted her because you wanted all the Baduisms, and she ain't here no more. Not wishing bad on Erykah and her Baduisms, but, just coming up with something. Or the other possibility, especially because they do talk about whether or not he fits within the law, the other impossibility could be them arguing the changes in the law, like when Adams got rid of it, or when it existed versus when it didn't exist, because we're going to get into those later in some of the affirmative defenses. So there is also the possibility that, like defenses 3 and 4, when we get into some of the other ones, that one is supposed to meet and marry up with this doctrine of impossibility, because standing on its own, it's but again, tossing in everything but the kitchen sink, you're trying to defend your client. I get it. Okay, the 6th affirmative defense, fairly straightforward: unclean hands. He can't accuse me of evil deeds and me being the devil when he is a bad actor or a co-bad actor in this situation. You don't have clean hands, dude. You were down for the funky get down. This was mutual. If I did things to you, you did them to me too. I showed you mine and you showed me yours, and we were good with that. There was no coercion. There was none of that. So unclean hands, which of course would arguably go along with one of his other affirmative defenses, the 9th one, just jumping ahead real quick, which is unjust enrichment, which is, just like it sounds, you're trying to be unjustly enriched for something that, if it happened, now I'm saying it didn't, but even if it did, you were an active participant in. Now, even since I'm saying it didn't, then obviously the other argument would be that you just had proximity to me by virtue of the fact that you worked for me and were engaged in my ministry, and now you are trying to unjustly enrich yourself based on things that you know or think you know about me, things that I may have confided in you that may or may not have had anything to do with you and I's intimate relationship, but because of the closeness we shared, maybe things I shared to you about um, other relationships or things that I've been going through, and all the things of things. So that to me would be another one of those marrying up of defenses: affirmative defense 6 of unclean hands, and affirmative defense 9, unjust enrichment, standing both on his own and marrying up with unclean hands. Seventh affirmative defense: plaintiff's claims are barred in whole or in part by the doctrines of events beyond the control of defendant, impossibility and practicability, and or frustration of purpose. Very broad, but so I'm going to use some of the actual allegations in the case to break down what the argument likely is here. So let's start with impossibility. It's impossible because it simply didn't happen. Everything that you said is just a flat out lie. The email is chat GPT. It's got a lot of ellipsis in it, so maybe it is. All the things, it's just impossible, just didn't happen. Not only is it impossible that it didn't happen, but there's also impossibility as well, because these, even as it relates to the statute itself, and of course marrying up with some of the other defenses, it didn't happen in, none of this stuff happened in New York County. So there's just impossibility all over the place. Impracticability, kind of the same thing. Again, it just doesn't make any sense. Nothing you're saying makes any sense. How it is just impractical for anybody to even believe you. I was doing this right before I went into my sermons. We're in the back and I'm abusing you right before I do. Come on, it's crazy. Beyond the control of the defendant, whatever. That's a little bit weird. I'm not really sure what's beyond your control. If you're saying it didn't happen, it didn't happen, but beyond your control is All right. Eighth affirmative defense. I told you they are defended. Eighth affirmative defense: the complaint is barred in whole or in part by the doctrines of waiver and estoppel. So I'm going to go over those separately, and then we'll get into how they are likely attempting to apply them here. And by the way, unless I'm doing plaintiff's work on the personal injury side, other than that, I am an almost 30-year defense attorney. So I'm usually thinking from that side of things anyway. So this works for me. Waiver. The waiver requires a knowing and intentional act to waive a right. So your express, whether it's express or implied. So essentially, waiver, you were down with it. So you waived your right to complain about it now. Whatever we did, now I'm not saying we did anything. Remember, I denied everything. But if you believe it, kind of like the OJ, if I did do it, if you believe that I did it, Your Honor, or trier of fact, if it's in front of the jury, then he was down with it. So he waived the right to do it. This is similar to what I would argue in a divorce case. If somebody who is someone alleges adultery, and the adultery was a minute ago, but the person said, okay, fine, I forgive you. I really don't, but I do, and I'm going to stay with you, even though I'm going to hold it against you, and or not. I'll just suck it down and have it in the pit of my belly, and And every time you turn around, I'm looking at you and I'm going through your emails and all this stuff. But I forgive you and I'm staying with you. And however many years later, that person files for divorce, and the first thing they want to toss in is they cheated on me, they committed adultery and whatever. Now, if it's some new adultery that you just found out about, fine. But if you're bringing up that old adultery, then the first thing I'm going to say is you condoned it. And there's actually a doctrine for that. It's called condonance. You condoned it. And how did you condone it? You might not have condoned it in a moment. You may not have been like that woman. Remember that husband and wife ministers, the ones that had the church, and they had that interview that went viral with, what's the guy who just got married? He had the show about looking for the wife. But anyway, there was a couple who has a church, and it was a huge deal. I think maybe last summer into fall, they went viral because the wife was talking about how they cheated. How the husband was a cheater, like for most of their marriage. I mean, going all the way back to the early days, the husband was cheating, and there was a certain point where she would literally get his clothes ready for him, iron them, lay him out, so he'd go out and be with his hoes because, God told her this was her husband and this was just what they had to go through to get him to the other side. I'm not talking about that type of condoning behavior. You could also, under that umbrella, condone it after the fact by not taking action on the adultery, as in you file for the divorce and accuse them of adultery or whatever, by staying with them. Over time, especially if you try to argue that later, you are deemed to have condoned it, at least from a legal standpoint. Doesn't mean you condone them continuing to do it, but that particular instance that you found out about at that time is off the table. I know we went around the mulberry bush, but I thought I'd give you a sexier, more fun example. Plus, we are going to do some episodes where we talk specifically about divorce and matrimonial stuff, because there's always divorces going on, the celebrity stuff, all the things, and I get asked all these questions. So we might as well have a little fun with it and get into it, and you'll get some knowledge and maybe take some notes that might help you out. So, gave you a sexier example. Bottom line, waiver. You were down with it. Don't complain now. Estoppel. That focuses on fairness because it's supposed to prevent injustice, right? That's what fairness is supposed to do. The scales of justice, the whole 9 yards. It's the blindfold and all the whole thing. So, bottom line is that I believe the doctrine here, what they would be arguing in terms of estoppel here, because it's the way that I would use it from a defense standpoint, and that's all I can go by because I'm not sitting in the room with them. It just comes down to simple fact. You allegedly made representations, like in this case, they may say, again, starting at the top, I didn't do anything. But if you believe I did it, then I will argue that person maybe made representations. Those representations were relied on. In a situation like this, the representation would be consent. I mean, that's pretty much it. We're not talking about any underage stuff or whatever. Not that consent would matter anyway. But in a situation like this, I would assume it would be about the representations that were made to him. I relied on it to my detriment. You can't cry essay later. It's not fair to me to hit me with that now. I thought we were good. That's what I'm thinking, especially given that all of these defenses are very much, I didn't do it, but if I did, here's the defense for that as well. it's going to be very interesting to see how, if this makes it past summary judgment, what the arguments would even be at a summary judgment hearing, and then if it makes it past it, depositions, etc. I suspect that if this makes it beyond summary judgment, and I'm not saying it will, I'm looking forward to seeing the summary judgment motion when it's filed. If this case makes it beyond summary judgment, which again is a motion is filed at the very beginning of the case to try to get the court to throw it out. We see that in all the big cases. So I know I'm talking to you all like you know what all these things mean. And if I'm over explaining them, that's for the folks who haven't been hanging out with us for a while. But anyway, back to what I was saying. If this case makes it beyond summary judgment, I think then we'd be looking at a settlement, because the allegations are only going to get more elaborate in terms of more detail and uglier, because then you're likely going to go into a deposition phase, or heaven forbid, a trial on this. And Mr. McClurkin has a church and a reputation on the line, and his ministry is held by a very thin thread of individuals who he feels has to believe, and perhaps they feel they have to believe, because there's a little funky undercurrent of why am I drawing a blank? It's been a long day, folks. There's a little thread of homophobia underlying all of this that we know is a thread that runs all up and through the church. And on the other side of that little thread is Donnie McClurkin saying, I'm healed. I'm cured. I don't like men's no more. I like women, in the words of Andrew Caldwell. And so the more this other narrative is pushed, it strains that very thin thread that was already quite thin, because these are the same people who and I grew up in the church, so I'm talking about my people. These are the same people who will have very obvious, potentially even flamboyantly gay individuals in prominent positions in the church, and somehow convince themselves that they're not what we and God and everybody else can see, and that their 20-year roommate is that they never bring to functions on a regular basis is just a roommate. And that's why they always bring their mom. Donnie McClurkin is not just someone who works in the church in one of those prominent positions. He is not just someone who sings in the choir or is an assistant, whatever. This is his church. It is his ministry. He is the one whose face is on the front of the CDs. And so that thread that holds together that agreement, if you will, between him, his church, and really the entirety of the gospel community and other churches, that allowed this suspension of belief into the land of wanting to believe, I suppose, that you can pray the gay away, and he is the poster boy for doing it. And so it is okay for us to, you know, buy his CDs and sing all of his songs and all the things. That um that agreement to live in that land of smoke and mirrors gets shattered. And it's a funky little place where the church has found itself many times with its leaders as well as its artists, and Donnie McClurkin is both. So this is a case that he can ill afford, and I don't mean financially, for it to go beyond where it is, because the allegations in that complaint are already pretty outrageous because they're very graphic. Um, and so let's just say he has benefited greatly from a fairly spectacular 2026 news cycle so far. Since January, there's been some pretty big celebrity deaths, and some that, that white and black people could agree on, that, it's like, wow. There has been lots of drama, even church drama, pastors and wives and guns and all kinds of stuff. All of whom, because they're all on my list, because we're going to get to some of them, happened right around this time, and even several cases dropping all over. For those who follow celebrity gossip or just follow church gossip, there's been a lot going on. And then, ongoing celebrity divorces. You got the Stefan Diggs stuff going on around this same time. Several young NFL players have come to unfortunate demise. You've got the orange one in the White House just doing all manner of things that are sadly impossible to ignore. So he has lucked out because it has not been a slow news day by any front in the entertainment industry. And while Donnie McClurkin is a big name and he's popular, oh, and we lost Richard Smallwood. I mean, that definitely would dwarf anything. He's certainly a big name, but compared to a lot of this other stuff that has gone on, uh, his situation was able to easily fall by the wayside, except for those who do stuff like this and really dig deeper and talk about them. And also he issued just a blanket denial like on day 2, and didn't go back and forth with the person. He just issued a blanket denial. The guy did do a magazine. The guy did appear in a magazine, or what was a website? But anyway, he did it. He did an interview. So there was also not that speculation of who is it? Who is it? It was pretty much everything came out all at once. He did a blanket denial, and then there are 5 million other things that took him out of the news cycle, namely like pastors and wives, literally like one wife like shot a guy, it shot the pastor husband. I mean, it's a mess. So that helped him in terms of being in the mix of the news cycle. And of course, he's not like huge, big crossover famous. So that has definitely helped. But a case dragging out still isn't going to help with your immediate church who knows about it, and certainly not within the gospel, the Black gospel community, and his generation of artists. So this has to go away, and if not by summary judgment, it's a trial wouldn't be in his best interest. And I certainly understand him alleging that this didn't happen, but the stink of this, especially in light of his past and that whole I'm not gay anymore thing. Um, yeah, it doesn't just make it drop. It's kind of like the Tyler Perry thing because of what people in his fans deliberately choose to believe versus about him versus what many, including those same fans, suspect. It makes it harder for the pretty ambiguous looking men who claim that he has crushes on them and tried to push up on them and had these weird relationships with. It makes it harder for it to go away because these things are being alleged against somebody who's, you know, people are choosing to believe something that they kind of know might not, or at least suspect might not be the case. And this upsets the apple cart on that. Okay, so let's see. 10th affirmative defense, because the 9th one was unjust enrichment. We're almost done, guys. The 10th affirmative defense, if any of the events alleged in the complaint occurred, which the defendant vehemently and unequivocally denies, the alleged incidents were welcomed by the plaintiff. So, that is classic, OJ. Didn't do it. But if I did, here's how it happened. Now, in this case, it's not here's how it happened. I didn't stab her to the right. I stabbed her to the left. And this case is, it wasn't at my house, not with a mouse, not at the church, not at a hotel, a motel, or the Holiday Inn. Not ever. But if I did do it, he wanted it. I'm just saying. If we gonna keep it real, he wanted it. He knew I wanted him. He wanted me. He didn't want to be gay. I didn't want to be gay either. But we decided if we were going to do it ever so often, we were good with doing it with each other. Not my words, their words. Nobody actually said this. This is me just pretending. This what's going on in my head. Very scary place to be sometimes, especially when it starts to get late. So that's the I didn't do it, but if I did it defense. The 11th affirmative defense, if plaintiff suffered any of the damages alleged in the complaint, again, it's getting late. Sorry, I'm talking over myself. Such damages were suffered solely as a result of his own negligent, reckless, unlawful, illegal, or improper actions, practices, and or conduct. And its culpable conduct is a bar to any recovery against the defendant. Now, this is a nasty one because basically it piles on to the I didn't do it, but if I did it defense. And it takes it a step further. If he's damaged, if he's hurt, if he's in any way, it doesn't matter if it's physical, mental, emotional, whatever it is. If homie was damaged in any way per his complaint, the damages were his fault. He put himself in the way of the harm that he alleges was caused to him. He was fine with crawling into my bed or me crawling into his. He was fine with me cuddling him, even if it sometimes went a little further. He was fine with whatever slap and tickle that went on in the back of the church office before I took the pulpit. And look, he kept coming back every week for more. He put himself there because that's what he wanted. And if he's damaged because of it, if he's conflicted because of it, if he's dealing with the psychological ramifications of still struggling with his sexuality, so he's beating himself up about it, or that he just realized that he had wasted 10 years of his life on some dirty old man, that's on him. Get a counselor, and when you do, pay for it your damn self. Better help is out there. Go get some. And it's ugly. This is one of those ugly ones. This is one of those, why did you keep working for me, allowing me into your hotel room, spending the night at me years after you left? Why'd you allow me to roll up on you? Because you were down with it. You told me where you were. You invited me into those places. And if you're effed up by it now, as they used to say with the tuna cans when I was growing up, sorry, Charlie. The 12th affirmative defense, because his attorney is getting real elaborate. He's barred by the doctrine of latches. Okay. This is old school, because again, he's bringing up his attorneys are going in with everything. So I'm going to give you the really legal definition, because again, we're the smart folks, and then I'm going to give you my opinion on it. So latches is a doctrine in equity where the courts can deny relief to the person making the claim, in this case Giuseppe, making a claim with an otherwise valid claim. So this is the person's making a claim. Let's say the claim is valid. Something actually happened to them. When the party bringing the claim unreasonably delayed asserting the claim to the detriment of the opposing party. So this is where that whole, dude, how long has it been? You allege that this started in 2013, and I'm sorry, 2003, and it went on to 2013. Even if that's the case, and yeah, that's a long time, but it was also still a long freaking time ago. It is 2026. Anyway, they goes on to say that latches doesn't apply merely due to the passage of time before bringing the claim. This is the critical part. The justification for the doctrine of the delay was unreasonable, and the change conditions during the delay may render the granting of relief sought inequitable. So again, very convoluted, because it's not just about the delay itself. It's the court also looks at why was there a delay, and because there's three pieces: the delay, which is a concern, but why there was a delay, which gets you to go, okay, but why? Because there may be a good reason. But there's still the third piece, which is that due to potential conditions or change conditions, especially due to that delay, it could still render the granting of the relief sought inequitable. Now, this is very convoluted, and it's tricky as it relates to SA. And for those listening on YouTube, you understand why we're saying SA. Is particularly difficult as it relates to SA. So this is not a slam dunk, because obviously delays can be excused and are often excused when it comes to SA, especially if the victim was a child, recovered memories, and also because even with what can be argued to be some inequitable impact on the defendant, there has certainly been acknowledged over time, grounded firmly in just the psychological impact that when it comes to certain crimes, and SA definitely being one of them, that that almost outweighs everything, especially if the victim was a child. Now, he wasn't a child, but I'm just giving that as an example as to why, when it comes to uh, the underlying crimes alleged here, um, that the delay in time is not a slam dunk because of the nature of the offenses itself. It is a very tricky balancing act, with certain stuff, um, and and also, if there's no other bar like a statute of limitations, there's ample reasons grounded firmly in the social and psychological stigmas that everybody understands, that gives the court pause in turning victims away. Um, we're simply, for one of a better way of putting it, more evolved now. And granted, we still have a long way to go, both as humans as well as in the law. But we've also come a long way since, even as recently as the 1980s, in terms, or even the 1990s, um, in terms of how victims of sex crimes are treated. So that one, like I said, very convoluted. And when you get into these types of cases, even that time bar piece, even with the other things, is just not enough. Now, that being said, this man was not a child, because of course that's just a whole other thing. They were not, at least from from their own allegations, otherwise disabled, conflicted about his sexuality, but not disabled. There's no allegations of any type of mental or physical deficiency. So that lends itself to the court actually, you know, alleged underlying sex crimes or not, it opens up the conversation. But again, you also have that gender motivated violence act that kind of could override all of this, because it opens up the statute of limitations anyway. So, again, kitchen sink. I'm not mad at them trying. It's just a little convoluted for my taste. 13th, affirmative defense. Plaintiff's claims are barred in whole or in part by the applicable statute of limitations. This is where they're going to lean into the statute that's the pin that all of this turns on. And they kind of have already said it twice. They just kind of keep saying it in different ways. The door opened by that act, and the ancillary doors on the side of the building that it opens because of the nature of the offense. I think they got a better shot at arguing the location piece to not even get that law applied. Because if they win on venue and that law applies, then any of these arguments related to the statute of limitations kind of fold with it. If you can if you can find a way for that to not apply, then the door is wide open with this other stuff. Okay, 14th, affirmative defense. This is another one that's a bit of a reach, but hey, I'm gonna hand it to them for trying. The plaintiff's claims are barred by novation. A novation is an agreement made by two parties under a contract to allow for the substitution of a new party for the existing one. The original contracting party, who's replaced by the new party, is excused from the novation, and therefore the original party is replaced and gives up any rights they have against the other original party. He's not suing the church, he's suing him. So, that one is a bit of a stretch. I'm just going to leave that out there on its own, and will be interesting to see what they're doing. I even put a question in my notes here. What contract was made or replaced here? Is was there an alleged contract for sex? Because you said that none of that ever happened. Who knows? 15th affirmative defense plaintiff's claims are barred in whole or in part by his failure to mitigate injury and failure to mitigate damages. I also noticed that there's a lot of his and her mix up here. So it looks like his attorneys did a lot of cutting and pasting from somebody else's case, because they didn't even make sure that they used his and her properly. The person here is a man. So I'm calling a flag on that. I totally understand not reinventing the wheel. We all do it, but at least get the gender of the participants in the case correct. So, failure to mitigate injury and failure to mitigate damages. This is just a further, I didn't do it, but if I did, they should have quit so they wouldn't have had their injuries. They should have stopped screwing with me. They should have just not come around me, especially given the alleged incident that they claim happened with the other guy before I allegedly took advantage of them. They failed to mitigate any injury or damages by just going about their damn business from literally day one, when he came to my little church without walls and one of the associate pastors tried to penetrate my walls, and I had to basically complain about them. And then, we ended up doing some other stuff anyway. The 16th affirmative defense, plaintiff claim damages are too remote or speculative to form the basis for relief. Okay, I get it. This one is it's fairly straightforward. Essentially, he's saying, again, I didn't do it, but if I did and you're claiming I damaged you in some way, given our age, given the nature of what allegedly happened, which I'm saying was consensual anyway, what was the harm exactly? What is the damages that the court could actually assess? What would be the dollar amount that gets put on a situation where, yeah, I'm older and arguably creepy given our age difference, and I may or may not have come on to you, and you may or may not have been down with it for the period of 10 years, going from the ages of 21 to about 30. How are we going to assess the harm in dollars and cents? Because ultimately, if you're saying I did something, the court finds I did something, damages need to be assessed for it, right? What's my punishment? What's my damages? Civilly, because this isn't even in criminal court. If we can't even come up with that, then what the F are we doing a case for? 17th affirmative defense, the plaintiff can't rely on CPLR section 2013C. And again, this is the expansion of these statutes that allow for these lawsuits. This is another one. When the statute was amended in 2019, more than 5 years had passed from the incidents alleged, and therefore any incidents alleged were already time barred and can't be revived by this provision. So, gonna try and break this down. Again, one of those convoluted ones, but you got to defend your client, so you're going for broke. Prior to the 2019 revision of this particular statute, civil actions brought by a victim of conduct constituting certain sexual offenses, and the ones that he alleges fall under this, battery and all the things, must have been brought within 5 years. The argument is short. This argument is a bit messy, because while the action was not brought prior to 2019, it was brought after 2026. It wasn't brought prior to 2019, but it was brought after 2019, and also after it was revived in 2026. The whole point of any of these statutes was to broaden the look back period. So you're looking back. So the whole point is to take into account that for a myriad of reasons, victims simply don't, or they're not in a position to, perhaps because they're a minor, no one did it for them. We talked about that earlier. But they weren't in a position to bring the case for whatever reasons, the stigma, fear, all the things. We talked about all of this ad nauseum, whether it was here or the gazillion people Monday morning quarterbacking the Cassie case. Now, I get saying someone is time barred because they brought their action in 2018 alleging conduct that occurred in 2010. The court legitimately dismissed on statute of limitation grounds because that was the law at the time. And if there's nothing that says, like Mandani's Act, I'm sorry if I'm saying his name wrong, and I hate saying people's names wrong, but I also forgot to write it down. In that revision of the gender-based, gender-motivated violence act, in that particular statute, when the mayor made that that extension, he specifically, or the lawmakers specifically said, this time period between this and this date, I think it was 2023 and in 2025, there was some months in there, that those time periods, those individuals whose cases were dismissed because of the repeal that Adams did, those individuals have the opportunity, if they so choose, to revive those matters. This particular statute does not appear to have done that. So I would understand if he brought his case in 2017, 2018, hell, 2016. And 2018, because that would have been 6 years. If he had brought the case in 2018, alleging all the conduct through 2013, and 2018 would have been the year 6, and the court said, absolutely not, you're beyond the 5 years, case done. And it was, and that was legit. And he tries to bring the same exact case now. The argument there could be that, I suppose the defense would argue that when he tried this, all the same facts, same defendant, all of that, when he tried this, the case was legitimately dismissed by the law at that time. And when the statute was extended, it did not account for reviving any case that was brought and legitimately dismissed according to the statute of limitations that existed before 2019. That, yes, there was a look back period, but that look back period did not include reviving dismissed cases. That would be a legitimate argument if that statute didn't provide a look back period. I mean, didn't provide a revival like this 2026 one did. Where that argument gets muddy to me is, for me, is that he did not bring a case previously that was dismissed per the statute of limitations in existence prior to 2019. He brought the case now. So, at any rate, I've spent enough time on that. I still think that even if the court kind of allows them to play around in the sandbox on this particular argument regarding this particular statute, that if it doesn't get thrown out on venue grounds because of that whole New York County thing, then it will fall under the Gender Motivated Violence Act, because the look back period there would cover it. It doesn't seem to have a limit. It just says before 2022. So, you still have to prove your case. Plus, there's other affirmative defenses, but it's a little bit of a reach for that one, especially if it could survive venue. He'll get in on the other one, but go for it. Finally, the 18th affirmative defense on this. Any of the offenses alleged that occurred outside of New York State and New York City cannot be filed in this jurisdiction, nor may they benefit from any extended statute of limitations of this state. So that doesn't get rid of everything, because he's saying some of the things happened at the church, but it certainly it certainly does allow for arguments about whether or not there should be a limitation, a la what we call motion in limine, to say that certain alleged offenses shouldn't be talked about or have any evidence put forward on them, which would be the Florida incident, him going to him going to his house in Boston. There was some stuff out west, because again, there was a lot of travel involved. So that is where that comes, but that doesn't get rid of everything unless they win on the venue argument. So, hello, Shade in the City. Yes, you did catch a live. So I'm glad to have you here, though. Like, comment, subscribe. Well, you already commented, so I may have to just put this on the screen because I'm so excited. So to have it. Yes, so that's my girl, Shade in the City. So at any rate, that is where we are. This is all going to hinge, in my opinion, on whether or not this thing makes it past summary judgment. You all know from when I originally talked about this that I found the entire thing to be kind of out there. Didn't say it was unbelievable, just out there. And I mean out there because of just the behavior generally and over the period of time. I think where it strains many of us is, again, that length of time, the age of the individuals involved. The whole thing is just a little weird, and I think that it is something that a trier of fact may have a little bit of trouble with it. That doesn't mean that it won't make it past summary judgment, and that doesn't mean that doesn't open the door to somebody writing a fact check just to make the conversation end. Because again, if they don't get this kicked right out the gate on motions, that means more interviews, depositions, people talking about it, and it potentially going to trial. And in a situation like this, even when you win, you lose, especially because of the broader implications of this as it relates to the church and McClurkin's murky, no pun intended, sexuality. And, again, the whole pray the gay away trope that based on the allegations is what got us here in the first place, which also gives creep vibes, especially in light of that whole idea of somebody in your camp trying to push up on me. Then I come to you, you're the hero, and then the next thing you know, I'm getting done by you. So it's there's a creep element, there is the church piece, there's the that, like I talked about a bit ago, which I'm going to clip out so it can be its own separate piece, that very bizarrely thin thread between suspending belief and homophobia, and where Donnie McClurkin kind of tap dances on it. So it's, again, in light of all of those things, even when you win, you lose if this goes to trial, because no one, and I'm not saying that you don't go to trial, because if you go to trial and you win in terms of you not having to pay this person money, then great, you don't have to pay this person money. And for those who choose to believe that it's all a lie, then great for you as well. But for those who were just suspending their belief to rock with you, it's a hit. It's and I don't mean a hit song. You take a hit. But everybody deserves and has a right to their day in court, and at least for now, that is what McClurkin is doing. And are there allegations that I think are making a lot of people cringe and feel comfortable about because they believe them? Maybe not believe it was forced. Um I think that's where the rubber hits the road in this, because I think that you're hard pressed to find folks that don't believe that there was a relationship of some kind. Well, you know, I'll leave it at that. A relationship between these individuals. The only question really seems to be is whether or not it was one of coercive control, force, and the like, lending itself towards allegations of SA and battery, and of course it falling under the purview of the Gender Motivated Violence Act, which gets this gentleman into court against Pastor McClurkin. All that being said, I am truly thankful for those who have hung with us and has joined in on this. I know it took a while to get this one up and running. Like I said, Timothy Busfield up next, but McClurkin's answer came, so that was certainly a little bit more timely. I will continue to add to my shorts. I'm doing shorts, so you guys definitely go over there. They're still on this page, of course. This is for the YouTube folks. Lots of shorts. I'm going to continue to do those so that you can at least get my brief opinion on things as they occur, as we get into the groove of doing these weekly and twice or bi-weekly. I'm hoping to do at least 2 a week, not bi-weekly, twice a week episodes on the good stuff and our pop culture stuff as it relates to the law, and and the drama. Doesn't have to be legal, but somehow it ends up being that. And also look out, because the goal right now, we're trying to work out the dates and accommodations and all the things, because I am not far from I'm in the DMV, so I'm not too far enough from Carroll County, where the Wendy Osefo trial is going to be. Well, actually, everybody is far from it, but I'm not across the country. So I definitely plan to attend that barring unforeseen circumstances, and go there daily along with Treese from Shade and City. So everybody, please follow her. Love the page, and we have a great time over there talking about Beyond the Gates. And she is such a wonderful I'm sorry, wonderful reviewer. She talks about Beyond the Gates, and then she and her sister talk about some other shows as well. So definitely check out my girl Treese at Shade in the City. Other than that, if all hearts and minds are clear, I'm getting it from church, right? Hey, we talking about a pastor. So everybody out there, like, comment, subscribe. You know what to do. Podcast folks on all the platforms, you know what to do to keep us out there. Let's keep this moving, get the algorithm strong, get those numbers up. I definitely want to reach that goal of 1,000 by April. That is my goal. We are going to do it. And you guys are the key to making it happen. So please share with your friends, post the episodes or even the shorts, whatever you like, on your respective social media. I really appreciate it. And as always, if you're thinking about it, talking about it, or you want to talk about it with me, chances are I'm thinking about it and I want to talk about it too. So let's be honest together. Bye-bye.